Good morning, ma'am.
Good morning.
Yeah, good morning. Oh, welcome, Professor Elizabeth. We have been waiting for you.
That's right.
We are live on YouTube.
Good morning, ma'am.
Let us, good morning. Should we, it's with me, it's 9:31. Should we start right away or should we just wait for a minute or so?
No, ma'am, we can start.
Okay, YouTube, maybe you have,
Yes.
I mean, okay, fine. Professor Chitty, can we start? Professor Elizabeth?
Yeah, sure, absolutely.
Ready when you are.
Yeah, start, Kshitij.
Okay. Thank you, ma'am. A very heartfelt welcome to our two distinguished speakers, Professor Dr. V.S. Elizabeth, Vice Chancellor, Tamil Nadu National Law University, and Professor Chidi, Professor of Practice in International Human Rights Law at the Fletcher School, Tufts University. We are here to celebrate the International Women's Day, and I welcome all on behalf of Faculty of Law, University of Delhi to this webinar. I invite Professor Dr. Usa Tandon to welcome our guest and give a welcome speech. Before that, I will just briefly, go through her profile. She's an eminent professor of environmental law, population law, gender justice, and family law. With the teaching experience of more than 30 years, she is world's renowned scholar for her work.
I think
I'm just summing it up,
yes,
ma'am.
so mine is
So
not
her
I'm
main
the
area
host and, yes.
main area of interest is population
Thank
law,
you
and
very
she
much.
has been very much,
Thank you.
engaged in
Let us
women
start
studies.
because
Okay, ma'am, please go ahead.
Yeah, thank you very much for that gesture.
Okay.
It's the participants are my students only, and I hope they're aware of it. Thank you. Dear and esteemed Professor V.S. Elizabeth, Professor Chitti Enslam Odinkalu, if I'm pronouncing your name correctly, Dr. Kshitij Singh, Dr. Narendra Bishnoi, my esteemed colleagues, and dear students. Now, since it is an event to celebrate the International Women's Day, so at the outset, I wish you all a very happy and fantastic Women's Day, though it is belated. Some of my job has already been made easy by Dr. Kshitij. Primarily, it's my welcome note and to give certain introductory remarks. It's my honor to welcome Professor Elizabeth and Professor Odinkalu, who are renowned scholars in their areas on human rights and human rights of women. When I thought of speakers for this event, I was very clear in my mind that it's going to be a mix of man and a woman. I never thought of exclusive speakers of female. Why? Because when we see the women questions or what progress has been made with respect to the real development of the woman or empowerment of the woman, we find that we have very many good laws, we have very many good policies, but still that desired progress with respect to the woman status has not been achieved. What are the reasons? There may be many reasons, but one of the reasons surely is that though the fight for the woman was started by men, but later on, when this fight was taken over by the women themselves, gradually, the men's participation has decreased. And this is somewhere or the other one of the reasons that why we are not able to achieve the desired goals. Therefore, when I was thinking, so this was my effort. So I was corresponding with one of my our alumnus, Bajanti, who's a scholar at Fletcher School of Law and Diplomacy. And during the course of the conversation, she talked about Professor. Uh, and the way she has expressed me about the scholarship of Professor Odin Kalu, I immediately reached out to him. And Professor Odin Kalu very graciously acceded to our request. And Professor Odin Kalu, on behalf of myself and on behalf of the entire Faculty of Law, University of Delhi, I extend you a very warm and cordial welcome. Now, having obtained his consent, my search was to find out a woman jurist. And then in that search, I found Professor V.S. Elizabeth, Vice Chancellor of Tamil Nadu National Law University, who has worked extensively on women issues, particularly violence against the woman. And he's going to enlighten us on that itself, conceptualization, how we conceptualize the violence against women. Madam, we extend you a very warm and hearty welcome. Well, I will just take a minute more and will say that when we talk about the women issues or the women concerns, to a certain extent, their situation has been improved. There's no doubt in that. But still, there's a long way to go. And gendered roles or stereotyping has changed, but to a certain extent, not to the desired extent. Now, let me share with you one anecdote. It's more in the form of a question. So, my dear students, and all of us, yes, all of us, get ready for the answer. Okay, so that anecdote in the form of question is like this. There was a father who was bringing his son to a job interview. The son has applied for a position at a very big stockbrokers company. When they had reached the company's parking space, the son got a call. And he looked at the father. The father says, go ahead and pick up your call, answer it. The son picked up the call. The caller was the CEO of a trading company who said, good luck, son, you will surely get it. The call ended. The son looked at the father who was just sitting next to him. The simple question is, guess, who was the caller? I give you 10 seconds. And let us see, can we come to the right, can we guess the right answer? Well, something might have come in your mind. As a matter of fact, this question was put to a group of 20, 30 people. And that group of 20, 30 people, all were highly educated and all were highly placed also. Not only this, they also represent different generations, more young generation. One thing more, that group also represented the diversity, the global diversity. The group included the persons, the boys and the girls, both from Asia, from Africa, from Europe, from America, everywhere. And how they have conceptualized to find the answer to this question. They said, okay, it was a call of the CEO who said, good luck, son. But the father was sitting on the side of the son. So who could be that? Some of them said, from the group said, oh, it could be the video recording of the father, just to motivate him for the interview. Others said, it could be the grandfather, and he could be the grandson, and therefore grandson is also referred as the son. Some has even gone to the extent of saying he must be having two fathers. So it was called from the other father. Some have answered by saying his name might have been son. So on and so forth. I'm sure you're curious to know the right answer. Should I tell you the answer to this question? The answer is the caller was the mother of the son. Now, how do we relate it to this program? When we think of CEO, we are starting conceptualizing a male figure. So when it comes to the position of powers, women are not thought of. And this was a thing. Now, here I relate the kind of group to which this question was put. They were all not only educated, but highly placed and who were under the impression. This question was not put to persons on the street. This question was not put to a lay person. This was put to that group who was already holding the positions and who were already under the impression that they are above the stereotyping. But still the fact that the persons like you and me who believe, who are working in this area and who believe that we have broken the stereotyping, but still somewhere or the other in our subconscious, it still remains. So we are eager to listen our distinguished speakers who will enlighten us that how to break the stereotyping when it comes to, or how the offenses against the woman are conceptualized, and as well as how to break the stereotyping when it comes the financial powers of the woman. And another stereotyping, how to deal with that when it comes leisure. Can we ever talk about women vis-a-vis leisure? So with these words, I wind up my address by welcoming our speakers and each one of you who is tuned with this program. Thank you.
Thank you so much, ma'am. You have presented the perception of the society regarding the women and womanhood, how they were treated, and how the perceptions can figure out that who is speaking and who is not. So it is very defined role of women which has been there in the society, which you have just portrayed very well. So now I'm inviting Professor Dr. V.S. Elizabeth. She is the 4th Vice Chancellor of Tamil Nadu National Law University. She worked as a professor teaching history and feminist legal theory at the National Law School of India University, which is in Bangalore. She was the first faculty with a master's degree in history to join the faculty of NLSIU to teach history in what was then an experiment in legal education in India, and which later on became a part of the 5-year law course. So she has a very notable achievement. She was invited by the National Commission for Women in 2003-04 to be part of the team set up to plan and design the curriculum of teaching feminist jurisprudence in the law colleges and law universities of the country. She was invited to join the group of law teachers from various parts of the world to found the International Association of Law Scholars. She was one of the founding members of the governing board of IALS, and in 2012-13, she was appointed as a member of the high-level committee on the status of women by the government of India. She loves teaching history and teaching young people, and feminism is a way of her life for her. Without further ado, I invite Professor V.S. Elizabeth. Now over to you, ma'am.
Thank you, Dr. Kshitij Singh, for that introduction. And my heartfelt thanks to Professor Usa Tandon for inviting me to speak on this occasion of celebrating the International Women's Day. In fact, I think it's quite a privilege to be addressing the students and faculty of the Delhi University Law Faculty. I am happy to be sharing a few thoughts that I have on the way in which we conceptualize crimes against women and doing it from a feminist perspective. Some of the scholars who have influenced my way of thinking and therefore the way in which I teach feminist legal theory and feminist jurisprudence are, of course, Catherine McKinnon, whose book Towards a Feminist Jurisprudence, Feminist Theory of State is, kind of the text on which my own thoughts have evolved from. And then, of course, there is Lucinda Finley, her article on breaking silence, as well as Anne Scales, Robin West, and several others, whose conceptualization and critique of the law as it exists have greatly influenced the questions that I have begun to ask. And therefore, this particular session where I want to share with you my own thoughts about it. Now, as Professor Usa Tandon was saying, at the beginning of this webinar today about the fact that there are several things that have improved, many things that have changed, but one of the things that really haven't, completely gone away is the question of the violence against women. The fact that violence against women is even now so widely spread. And for us as law students and law teachers, it is important to even see the fact that about 20% of the cases of violence against women, be it domestic violence or sexual assault, are actually reported. So if for every 100 cases of such violence which takes place in our society, only 20% get reported in India. In the UK, it is as low as 5% of sexual assault cases are actually reported. And when you look at the rate of conviction, you find that only 20% of that 20%, end in conviction. Now, as a result, you have all these kind of comments which come, that there is false cases that are, made against men, to the idea that, there is misuse of the law. In fact, almost everyone in such forum always talk about, misuse of the law, misuse of 498A, misuse of the Domestic Violence Act, misuse of the sexual harassment law. You constantly keep hearing about it. And I remember, the former Justice Roshan Dalvi of the Mumbai High Court, who was saying, that on a regular basis, people are misusing various laws, and there are provisions in the CPC to take care of that. But nevertheless, the only misuse of the law that all of us hear is about women misusing the laws that are there to protect them against, violence. And for me, when you're comparing these statistics, on the one hand, your statistics would saying only 20 cases are reported, 20% of cases are reported, only 20% of that ends in conviction. And on the other hand, you keep hearing that there is misuse of the law. I'm not able to put the two things together. If it is so easy to misuse the law and women are misusing the law, why isn't there a higher, percentage of reporting of these cases? Right? Maybe you can explain the low level of conviction on the grounds that because they're all false cases, therefore they're all being acquitted. But why only 20% of the cases that happen are being reported? And to give you again in very practical terms, because I'm a feminist and believe in feminist legal theory, so I don't believe in talking in the abstract. I'll talk to you in practical terms. Just taking one example. A few years ago, there was one of my students at the National Law School, Bangalore, who was sexually assaulted in a neighboring campus. So the campus is, large, the Bangalore University campus, it's not fenced off. They have sandalwood trees, etc. there. So there were always regularly a gang of thieves who were coming down to cut these sandalwood trees, and they would hang around the campus. And my former student and a friend of hers, they were sitting in the car. She was showing him some photographs of mutual friends, and they were just sharing and talking and discussing when suddenly they were surrounded by this gang of about 8 men, and they made them open the car doors and get out. So 2 of the men caught hold of the man that she was with, her friend, and took off his wallet, his credit cards and things like that. The remaining 6 took her away from that scene. And then she told us how she was made to walk, quite a while. It's quite a little bit of forested area. So they made her walk through that, forest. It's not densely forested, but nevertheless. And in the process, she lost her chappals. And then, one of them actually gave her a pair of chappals to wear, and they took her in, and then they raped her there. And she thought at that point in time that she was going to be killed because they all looked, scary. And, there's a gang around. So she didn't expect to be let off. So she didn't really particularly notice the first 4 or 5 people who had sexually assaulted her. And then when she realized that they're not going to rape her, being a law student, she began to closely observe them. Remember, this is about 9 in the evening, so which means there isn't much light that you can see anything by, but there were street lights, around the campus, and some of that light was reflected even in the area where they had taken her. After they had assaulted her, they took her, made her walk again, further into this area. And once again, they assaulted her. 8 of them assaulted this young woman. And then after this, they wiped her clean. And, they dusted off because, they laid her down in the forest, right? So it is all dry leaves and mud and everything. They dusted her off. With the slippers, they brought her to the road. Then they took off, they asked for the slippers back, and then she walked. She reached the campus, and then her warden and the person who was in charge of the mess, they met her. Then with the help of them and friends, she went to the police station, which was in the same neighboring campus, reported the crime. And do you know why I'm narrating this? Because when she reported this crime and the police began to investigate this, because they had taken off a mobile phone, it became easy for them to track these guys. So they caught all 8 of them based on the description she gave, and the police artist, who drew their figures. Based on that, they arrested all 8 of them. During interrogation, they learned that she was a 32nd victim. Not even one of the victims before her had reported this crime. She's a 32nd person. Because sometimes when we say 20% reporting, people wonder if we women are making up these figures, and we are falsifying such evidence. I just wanted to use that as an example of how often this does happen. 32 women were gang raped, but none of them reported. My former student was the first person to report it. If even one of them had reported this before her, she would have been saved this trauma. Because being sexually assaulted by one person can be traumatic enough. Imagine being gang raped by 8 men and repeatedly. And if the first woman had reported the crime, 32 women could have been saved that. But because of the way our society functions and the way the law functions, women hesitate to report. So that's a point that I want to first make. The fact that there is low reporting of both domestic violence and any form of sexual violence. And it is really, really low. We're not talking about, 50% or anything. We're talking about only 20% of cases being reported. And then comes the second point for us as law students and law teachers, law researchers to think and reflect about. Why only 20% end in conviction? And all of us have studied, these cases of sexual assault and domestic violence, dowry-related deaths. One of the studies that we did way back in 2002, 98 to 2000 is when we did that study, and we published it round about then. In that study, again, we found the same thing. Numerous young women who died soon after their marriages. The cases were filed under Section 304B, but when the case went to court, the court ended in acquitting all of them who had been accused of it on the grounds that they have not been proved to have actually caused that violence or caused the death or the abetted in that death. But all of them are identified as unnatural deaths. Women between 18 and 25, soon after their marriage, have died. And there is, violence on their bodies. They have either committed suicide or they have been burned to death. And yet there is not enough evidence in order to convict those who had been responsible for the death of these young women. These are just two examples that I'm taking in order to say there is something seriously wrong with the way in which we conceptualize these crimes against women. Because if you look at IPC and the way in which, we first of all define an offense, in fact, how we even include them, keep in mind we are yet to criminalize marital rape. Sexual harassment was not criminalized, till the 2013 Act. Offenses against children, sexual offenses against children were not criminalized till 2012. As a consequence, there are numerous cases of sexual offenses against children ending in acquittal of all these men. And then, of course, sexual harassment, unless you can show it as outraging of the modesty of woman, as well as, show it under 509 as, obscene songs, obscene gestures, etc. So you'll have to, again, define what is obscenity and everything else. So my point is that the way in which we have conceptualized them itself is problematic. And then comes the way in which we understand these crimes, and therefore the procedure for trying persons who are accused of these crimes, the kind of evidence that is called for, resulting in acquittals rather than justice for the women who have died or the women who have survived such crimes. That is one part of it. And I will, take examples just a little later. The other point, and I'm sorry, I have about half an hour, right?
Yes.
Yes. Yeah, okay. Thank you. Yeah, I just didn't want to overshoot the time limit. The second point, and in fact, possibly the fundamental point that I want to make is the law is not objective or neutral. All of us teach the law as being objective and neutral, that it is universal. But it is actually a very gendered law. The way in which the entire, all the laws, whichever law you want to talk about, I'm not just talking about family law and criminal law, which is what often, we engage with when we talk about women-related issues, constitutional law, corporate law, insurance law, banking law, all of them are gendered. They only see issues through the eyes of a man. They have looked at, and again, of course, a privileged man. I'm not saying all men's issues are actually conceptualized here. Dalit men, Adivasi men, and other men who are marginalized are definitely not included in the way in which laws have been, compiled, the way in which laws have been drafted. They definitely do not include any of this. Any of these groups of people. But since I'm focusing upon women, and therefore I'm restricting my criticism only to that. Right. So when you look at the law, it isn't objective by any stretch of imagination, because the offenses that have been described or the kind of rights that are protected in the various laws are all seen through the eyes of men. And as a consequence, they have neglected not only the issues that affect the lives of women, but more importantly, they've completely ignored the impact of these gendered laws on the lives of women. Just take an example of that would be, let's say from insurance law. Insurance law doesn't take into acknowledgement at all the medical conditions that affect women in particular. So if you look at what are the kind of health issues that you can get medical insurance for, it excludes something as fundamental as pregnancy. Society expects women to marry and get pregnant and give birth. And yet you find that medical health insurance, for the longest time, I'm not so sure, today if any of them cover it, but for the longest time, they never ever included pregnancy and pregnancy-related risks. Now, we'll need to ask the question why. You cannot be making the argument that these are special things. See, that would be the other problem that we have with the law. The idea that likes have to be treated alike, and when you treat people who are not similar differently, you'll have to prove the grounds on which they are different. My argument is that men and women are different in terms of the physical functioning of their bodies. Even if you look at the medical science itself, right, completely ignored these medical issues that affect women's lives, including something as common as heart attack. So the description of, the symptoms of heart attack are very much on lines with the way in which generally men experience a heart attack. Whereas most women, and especially those who are diabetic, The symptoms of heart attack are very different. It's not like a searing pain in your chest and then, pain in your left arm that tells you that, okay, something is wrong. It's very mild, just a little discomfort in your throat or in your abdomen, upper abdomen. And, there's barely any pain in your chest or your arms. And because of which people ignored, and women died of heart attack and nobody really took care of it. You find that something as simple as that, which a medical science itself, ignores, is something which you also find being ignored in the law. If I have to take, another example in terms of objectivity and neutrality of the law, would be in terms of, let's say, guardianship. Why does, the Hindu Guardianship and Wards Act make the father the natural guardian of all legitimate children? How is he the natural guardian? It is a mother who carries that baby in her womb. And it is only she who has to tell you who's the father. It could be any Tom, Dick, and Harry. But because she tells us, our father is the father, we believe her. And therefore, he, is accepted. But how does he become the natural guardian? And the mother only after. Even the Gita Hariharan case hasn't really changed that, because they didn't strike that section down as being unconstitutional. All they said is, if the father has no objection, then during the lifetime of the father as well, the mother can be recognized as the natural guardian. And, this isn't something which happens all the time. I'm sure women continue to struggle proving the fact that, the law actually gives them this provision. Now, therefore, when you look at the law, it isn't objective, even though we are teaching it as being objective. And because it is gendered, it essentially means that we are gender blind. As Janaki Nair, a historian, said, when we say something is gender neutral, we are actually saying it is gender blind, because it is functioning from the perspective of the male gender and ignoring women in particular and other genders as well. Now, that brings me to the point that I made earlier in terms of how these very concepts in the law are problematic. So let me take the issue, first of all, of something like sexual harassment. As I said, till the 2013 Act, we really did not criminalize sexual harassment. You had to prove it under Section 354 or Section 509. Now, Section 354 says outraging the modesty of a woman. Is that the experience of a woman when she's subjected to sexual harassment? In her mind, is it like, oh my God, my modesty has now been outraged? As someone who's been subjected to sexual harassment from the time that I was a school-going kid to as late as 10 years ago when I was about 50 years old, that isn't the thought that came to my mind when somebody touched my body without my consent. I didn't feel my modesty is outraged. That is the way men imagine it. They think that a woman should not be touched by any man excepting the man she is married to. That is not a problem for me. My friends can touch my body with my consent. I have no issues. But I don't want some man touching parts of my body, any part of my body, without my consent. And especially those parts that we consider to be private parts, that can only be with my consent, my very clear consent. I remember this incident even just 10 years ago. I was walking down this lane leading up to my house when a scooterist, suddenly overtook me and put out his left hand and grabbed my breast. I was angry. I wasn't, feeling outraged that my modesty has been outraged. I was outraged that even at 50 years old, when I'm walking down quietly down the side of the road, constantly we are told wrong place, wrong time, wearing wrong kind of clothes. I'm wearing, this is, January in Bangalore, so I'm wearing a sweater, I'm in jeans, and I'm wearing a long sweater, so covering my butt. So you can't even say, I was wearing something which is exposing my butt and therefore he got provoked. I'm not wearing anything which shows my breast. I'm wearing a sweater, layers of clothes. And yet he had been practicing so well, he grabbed exactly my breast. What was I outraged about? That my modesty? No, that somebody touched my body without my consent. I was angry. I was frustrated because what am I going to go and report in the police station? I can't identify this man. He's a total stranger. All I can describe is that brown jacket, and I still remember it, which is important when we look at the law. because it's the impact of that law which lasts so long as compared to a lot of other crimes. And this was, not Section 375 that I could invoke here. And this is the thing that I'm talking about when I'm saying the very conceptualization of crimes against women, till to 2013, the way we even conceptualize rape was purely from a man's perspective, penile penetration of the vagina. Why? Simply because it could end in pregnancy. I mean, is somebody's vagina penetrated by, weapons or, tools and implements any less humiliating and painful than, the penile penetration of the vagina? Remember Jyoti, or the Nirbhaya, as we call her, who passed away in 2012? But till 2013, amendments to Section 375, we didn't think about sexual assault in the terms in which women experience it. And as a result is, how you describe it in the court, and the fact that you need medical evidence, which is a two-finger test, and nobody ever imagines that two-finger test is the second sexual assault on the woman's body. And it is without her consent, because otherwise she can't even file the police complaint, right? Because only then are they going to say that, yes, we have done the medical evidence. What have you found? That she was habituated to sex, or you were able to prove that she was raped? You're not able to prove that she is raped by putting two fingers into her vagina. And despite the fact that this is all, been banned, you find that people still are doing it. And in the case of that student that I described, it was a lady doctor who examined her. And then because she didn't find any injuries on her body, she concluded that this was consensual, it is not sexual assault. I'm like, what's going on in your mind, lady? 8 men have sexually assaulted her, 8 strange men. You're saying she walked into that Bangalore University campus to solicit some 8 strange men and say, have sex with me, one after the other, and do it repeatedly? Just because you do not find, because keep in mind that anything affecting our muscles, when you injure it, it takes 24 hours before you'll actually experience the pain. This lady did not even examine the sole of her feet, which were bleeding, because she had walked through the forest. Because in her mind, right, sexual assault, you need to only examine her vagina. This is what I'm saying is problematic with the way in which we have conceptualized the law in those areas which affect the lives of women. Let's take 498A or the triple talaq, that we have criminalized now. Have we asked the women, what is it that they want in the context of domestic violence and divorce? Because 498A is cognizable offense. It is non-compoundable. And as a consequence of which, as soon as somebody files 498A, immediately the man and his relatives against whom the complaint has been made are all to be arrested. Is that what women want? What women want is that the violence stop. So when you look at the difference between the way in which 498A has been conceptualized and drafted, and look at the 2005 Protection of Women from Domestic Violence Act, you see a world of difference. Because the 2005 Act is a result of people like Indira Jaising, the Lawyers Collective, Flavia Agnes, and others, who had been practicing law in order to protect women who came to them with regard to domestic violence. Since there was no explicit law which could give them the remedies they sought, they used very creatively the CPC, protection orders, injunction orders, trying to find them, what do you call this, the monetary relief that they needed, as well as custody. This is what they fought for, even though there was no express law connecting all of these provisions with domestic violence. And what they did in the 2005 Act is to put it into that Act because they drafted it. That is a difference between drafting a law, keeping in mind women's experiences and the impact on women of the laws that are enacted supposedly for their benefit, and laws being just like that drafted, which is why our governments have never hesitated in giving us as many laws as we want, because it doesn't result in changing anything on the ground. Things continue to go on as they are. It's when you change the way in which you look at these crimes and define them that you can hope to make a difference in the lives of women who are affected by these kinds of violences. Let us take, 304B as another example. It says within 7 years of marriage, and there should have been violence or harassment soon before her death. How soon? Should it be 5 seconds before, 5 minutes, 5 hours, 5 days? How soon would be seen as soon before her death? Because if you can't prove that soonness, then, one of the grounds on which you end up failing. Second thing, you have to prove that the harassment. What is harassment? How do you conceptualize a harassment? From the way in which the reasonable man defines harassment, or from the experience of these reasonable women? Because when you look at the cases under 304B, you'll find again large numbers of acquittal, because either you're not able to prove there was harassment, cruelty, in the marriage, or you're not able to prove that it happened soon before her death. And therefore, on one or the other of these grounds, Section 304B is there, and everybody tells you, look, we have provisions in the law which are there to safeguard women's interests, when in reality, none of these have provided any relief to the families of the women who have killed themselves or been killed by her husband and his relatives. And so that is the reason why, an organization in Bangalore called Vimochana held public hearings, because the parents wanted some sense of acknowledgement that their daughters didn't die just like that. That the people who killed her, are being at least shamed publicly, if nothing else. And we had these public hearings in Bangalore about 20 years ago. Simply because they had been running from pillar to post, from the police station to the courts, and acquittals. Because you have to prove cruelty. And what is cruelty? How does a judge define cruelty? What is the criteria you use? Because if you do not take into existence a woman's experience of what she thinks is cruelty, because I remember one of the cases from Rajasthan High Court, it was, where this young woman supposedly, committed suicide. And in her suicide note, she said to have left the explanation saying that, she expected marriage to be romantic. She expected marriage where her husband will spend time with her, that they will be doing things together. Whereas, she found that on marriage, her husband was not at home, was not available for her. And the judge dismissed the entire thing on the grounds that this is, her romantic expectations of marriage, which are not practical. Now, where did she get those romantic expectations? The kind of things that we write for women, make available for women, the kind of things we tell women in order to persuade them to get married because that is a good thing for them. And is it romantic to or unrealistic to expect that at least in the first year of your marriage, your husband will make time for you and be there for you so that you can talk together, spend time together, do things together? That was the grounds on which the husband was acquitted. You have similarly a lot of other such cases where we're talking about mental cruelty. Like 498 provides for mental cruelty for the first time, but absolutely no parameters by which you will judge what is mental cruelty. It is for these reasons that I'm talking about the need to look at these crimes that affect women from a feminist perspective. To look at them through the experiences, through the eyes of women, because you cannot possibly understand what are these, what is the impact they have upon women if you do not ask a woman that, which is why the feminist methods of asking the woman question, feminist practical reasoning and consciousness raising are so necessary for all law students. If you don't use these feminist legal methods, you will just continue to perpetuate and reinforce gender stereotypes and reinforce patriarchy. And then, we can have these kind of, meetings once a year where we think about women. And the rest of the year, we can completely ignore the fact that most women's lives are impacted by violence both within their homes and outside. In fact, I know, that sometimes there are even teachers who don't even want to discuss them. So when you're looking at criminal law, we don't really, because there is such a vast, law that you sections in it. And there are teachers who will not even address Section 375, when for a criminal lawyer, that is your bread and butter. And yet we will not engage with Section 375 and 376. It is therefore why I'm saying, unless we look at the law through using the feminist perspective, especially looking at these crimes against women, you can look at all the other laws as well, be it family law or be it, business law or anything else as well, using the feminist perspective, and you'll see the way in which all those laws are gendered. Scholars, more expert in these areas than me have done it, and you can read them. You can see the difference. But for me, the concern has been about violence, because violence impacts every woman. Because you don't have to experience it. Just the fact that there are so many women who are subjected to various forms of violence makes you take decisions resulting from the fear of that violence. The kind of clothes we wear, the kind of courses we study, the kind of institutions we go to, the kind of jobs we take up, how we travel, whether we travel at all of these decisions, which are so necessary for our day-to-day existence, are impacted by the existence of this violence against women. Whether you marry or don't marry, even that is informed by the fact that there is so much widespread domestic violence. And that's the reason why my entire research and this last 20 odd years that I've been working on feminist legal theory have been informed by these concerns in the area of violence against women. I haven't stepped into reproductive rights or marriage and divorce or custody and those issues. For me, it has been this, because this is fundamental in the way in which it impacts women's lives. And when we take these concerns into consideration, then I think as lawyers and law teachers, it's not about reforming the law. It is about reinterpretation of the law itself, if not revolutionizing the law. Because reform is just adding here and there, like we did with the changes we made in 1983, 1984, 1987, etc. to the IPC. Saying prior history should not be taken into consideration, to the 2013 Act, where we have now reconceptualized what is a sexual assault. But it isn't enough to do those reforms in the law. Because at the end of the day, it is the way in which we interpret the law. So you can have good laws, but if the lawyers, the public prosecutors, the judges are still looking at them as men see them. In fact, Catherine McKinnon makes this very profound statement that the state sees women as men, see women, and therefore merely as objects, which is the reason why something like sexual assault, when you take the issue of consent, right? We don't look at consent at all from the way in which the woman expresses it, from taking a no to meaning a yes, to the fact that you have to prove that there was violence perpetrated on her body in order to say that there was no consent. These are all the ways in which men see women, women's bodies, women's lives, women's agency. And that's a way in which, therefore, these sections have been conceptualized. And that is the reason I think, she is so absolutely right when she says that the state sees women, the law sees women, just the way in which men see women. And that is in terms of objects. Women are objectified. They're not seen as human beings who experience pain, just like, men would. And that's the reason why we constantly talk very loosely that who can understand women? Women are so unfathomable. And, the fact that women come from Venus and men come from Mars, like as if, women are not normal. They're not human beings. They are alien creatures. And all of this enables us to justify the kind of crimes that are perpetrated on women. And so I end my talk here. I don't know if I have exceeded my time already, with just this one call to you as law teachers, law researchers, and law students, to look at every law that you are teaching, researching into, and studying using the feminist lens. Just asking 3 simple questions. How do women see this? How does it impact them? Because when Professor Usa Tandon was talking about men having begun this process, when you look at Raja Ram Mohan Roy or Ishwar Chandra Vidyasagar as men who began this, the question is, were women subjects of those legislations or merely objects? Because if women are not the subject of all this law reform, so-called law reform, it clearly explains why these laws have failed to protect women and their interests. Why there was a need for a hashtag #MeToo campaign when you already have provisions in the law to address sexual harassment. You need to ask, why did women resort to that? Then you will get the answer of the problem with the law. I'll stop here. If there are questions later on, then maybe I can discuss further. Thank you so much.
Thank you so much, ma'am. If I gather properly, you have produced, you can say, a feminist gaze on violence against women, and highlighting various aspects, like it is being alleged that there is a misuse of law by the women, which statistically is wrong, as you said. And apart from that, I mean, when we go by the reporting of cases, that is also a problematic scenario. And the most important thing is that how laws are being approached, whether that realization as a woman is there or not. So it is not, I mean, true that men are not, sensitized, or you can say they are not realizing this fact. There are stereotype women also who are responsible for this very thing also. I mean, if I add on that, because they are guided by that very perspective which was floated by the men. So they need to realize their own perspective, and men also should realize that in the place of women, if they place themselves there, then how they perceive the atrocities against the woman. So that is the most important thing which one must realize. And there's a need, as you said, rightly pointed out, that there's a need to approach the law differently. I mean, there are so many laws are being made, they are being tried to implement it, but unless and until we change the approach, we realize the atrocities, we cannot have a pragmatic approach to law. So thank you very much, ma'am, for this wonderful discourse. And I think that everyone is triggered to take this very issue seriously, and with all the approaches which you have provided here. So now I'm moving to the next speaker.
Please. I'm here to ask one question. Yes, Professor Mahavir Singh.
Okay, sir. We will be
No, questions are after. Let the other speaker also speak, and then we will have question answer session. After. Yeah.
Right now, I'm having in my mind.
You please write it. You, Professor Mahavir, we really appreciate that. You please note it down so that the other speaker, let us go by it's already in the USA, I think, 12 o'clock.
Okay.
Fine. More. It's midnight in the US, and Professor Audin is connected from there. Yeah.
As you wish, ma'am.
Thank you, sir, and welcome to this webinar. I couldn't notice you. So next speaker is Professor Chidi Anselm Odinkalu, if I'm pronouncing it properly. Is a professor of practice in international human rights law at the Fletcher School. He previously chaired Nigeria's National Human Rights Commission and served on the panel of eminent persons that negotiated the return of the Gambia to the Commonwealth in 2017. He has acted as a counsel in international human rights litigation before Africa's regional human rights courts and tribunals, and was involved in the creation of African Court on Human Rights, Human and People's Rights. He is associated with several advocacy initiatives for the protection of human rights, including the International Refugee Rights Initiative. And his research primarily focuses on the contemporary challenges of multilateralism in regional systems in development, human rights, and governance. He has authored many books like Too Good to Die, Third Term, and The Myth of Indispensable Man in Africa. So without further ado, I invite Professor Chidi to proceed further. Thank you. Over to you, sir.
Thank you very much, Dr. Singh. Good morning. The Dean, Professor Tandon, and Vice Chancellor Elizabeth, thank you so much. That was such a delight and enlightenment to listen to. And even if it's just for the privilege of having listened to you, I think this is well worth it. It's nearly midnight here, so that means I can file my allocators very early, so that I don't necessarily take responsibility for anything I say, as there could be short circuiting. But seriously, I just wanted to start with a word of appreciation to Professor Tandon and the community of University of Delhi. I consider myself a very privileged mentee of Upendra Bakshi, and who himself, of course, is a former vice chancellor of University of Delhi, and also Rajiv Dhawan from Bangalore, the law school, and so it's really a profound privilege to be part of this. It just happens also to be my mom's birthday. Actually, she's late now. She died 3 years ago. But today actually is her birthday, and so I wasn't going to miss this for anything. And having listened to Professor Elizabeth, it's very difficult to really say much more than what she did. So I consider myself more of a discussant actually to what she said, illustrating those points probably from a comparative perspective, validating much of that with insights from beyond India. And I come from a country that shares a lot with India historically, and in which India continues to exercise, it's not just a country, it's a continent actually, in which India continues to exercise tremendous influence in so many ways. Next year, of course, will make it 100 years since the Brits abolished the rupee as the currency of the East African countries, because they feared that the Asian traders and people of commerce in East Africa were going to put them out of business if they did not bankrupt them. Lord Lugard, of course, who was Frederick Lugard when he was in India, traveled out of India lovelorn and ended up in Africa and ultimately in Nigeria, where he wrote the manual on colonial administration, the dual mandate. And the Indian Penal Code, as a matter of fact, was also exported from India, from the Raj, right through and ended up in Africa, and indeed inspired lots of similar, lots of penal codes subsequently, including indeed the one in Nigeria too. And I could go on about this, but it's my way of saying really that a lot of what Professor Elizabeth has pointed to easily found its way into much of African countries, and the experiences and the underlying normative frameworks are not dissimilar at all. And so it's easy to identify with the points that she makes. And underlying all of that is the point about women's agency. This is the 105th year, of course, that we are marking March 8th as International Women's Day. And for those who, having listened to a professor of history and of law and the university administrator, history becomes relevant here, and history is relevant to pretty much everything we do. The Bread for Peace March in Russia in 1917, of course, is the origin of March 8th as International Women's Day, because that was the day it took place. And 4 days later, the Tsar abdicated, and history was changed with the Bolshevik Revolution. But really, the reality is that the Tsar was chased, the Tsarist system was sacked by women's agency. And that's really what I wanted to probably append by way of illustration to the broad canvas that Professor Elizabeth has painted. And in 3 dimensions, and I want to illustrate those or to talk about them as a structural aspect to the issues put forward by Professor Elizabeth, because there's an underlying structural environment here. There's an ecosystem that kind of provides the justification for much of what, or provides the architecture for much of what she describes. Now, those are found in one economic agency, access to credit, which is in Article 13 of the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, Article 13A, Article 13B. The second is access to leisure, which is Article 13C. And the third is equality of legal capacity in Article 15 of the Convention on the Elimination of Discrimination Against All Forms of Discrimination Against Women. And I wanted to focus on these. There's a fourth, of course, which is political participation. But a lot of people talk about political participation and for reasons that will probably become evident quite shortly. I do think that these other three are at least as important, if not more. But if you wanted to start with, because the IWD really is a celebration and a commemoration of the agency of women, and also marking not just how far it has come, but how much further it has to go if we are going to make progress as a collective humanity. It seems to me important that we address the issue of economic agency of women. And that begins, at the heart of that is access to credit in many ways. And one thing about that is that men are able to, if you looked at human progress as a consequence of a production value chain. And so how do we optimize the factors of production, land, labor, capital, data, management? All of these have been optimized through commodification, essentially. And so economic products have been developed around all of these. And the commodification of labor, of course, being something that we can all debate, and the consequences of that, of course, we can all look at. But the commodification of land and labor, but land and capital in particular, was powered through credit, which women don't have access to. And if you read the convention, the CEDAW Convention, of course, there are Articles 13 and Article 14. There are reasons why women don't have access to credit for the most part in most countries, and those are related, one, to cultural factors and also to structural factors. Non-remunerative, the fact that women are concentrated in, one, non-remunerative labor. Two, they're excluded from land holding and property holding, but for all manner of reasons: allodial land holding, family land holding, the fact that land holding is concentrated for the most part in men for no reason that is justifiable as an economic proposition. But when you look at all of that, the consequence is your average woman does not have the asset with which to participate in the economics of secured credit transactions. And through exclusion from secured credit transactions, she cannot progress to scale in economic value chains. And so what then happens as a result? It's not just exclusion that happens. You then begin to, because women are concentrated in non-remunerative, non-paid, non-acknowledged economic activities like caregiving, for instance, like work in the family spaces and in the cultural spaces. Participation in the exchange economy does not exist for many of them. And so when your average woman suffers violence, life-endangering violence of the sort that Professor Elizabeth has described in intimate relationships or in marriage, for instance, the incentive to run away for self-protection is trumped by the instinct that if she goes away, she'll be destituted. And a lot of women end up dying because of that sense that there is no economic agency. As the chair of Nigeria's National Human Rights Commission, the thing that kept me awake was not terrorism. Nigeria has a terrible situation of violence, as in large-scale terror violence. It didn't keep me awake. What kept me awake was intimate violence, because it represented somewhere between about 30 and 34% of the cases that we got. And these they covered every spectrum of the social hierarchy. I mean, you had high court judges, you had law professors, you had university teachers, you had senior politicians who were victims. And I lost at least two of them, actually. There was a third, and she was thrown out. She was thrown down from the building, the top floor of the building. By the time she landed, she was dead. And in each of those cases, you would have thought, oh, these people were formidable enough because they were supposed to be in relationships in which there was money, there were material resources, but just trying to arrange support mechanisms for them and protection for them showed up that in the midst of all of that material asset, they actually were destitute. And that incapacity to access economic activity and economic agency is central to the to endemic violence in intimate relationships, I'd wish to suggest. And for those who are interested in issues of sustainable equality for women, I actually want to suggest that it is one thing we've all got to work on across geography, east to west, north to south. And that is not just about access to credit for individuals, it's access to credit for organizing women as cooperatives in amongst peasant populations, among subsistence populations, and seeing how cooperatives can help to advance the solution to economic exclusion and exclusion from economic agency. Unless we address that, we will continue to have this endemic violence that does not go away. The second thing is access to support, social support. And that leads me to leisure. It's not something we address a lot. But increasingly, I'm interested in studying leisure and the disparate, the unevenness in access to leisure for men and women and its consequences, and it is colossal. If you go to your average place of worship in a lot of our communities, whether you're talking about East or West, particularly for some of the more traditional faiths, one thing you probably, first of all, women and men worship differently. And for many women in a lot of communities that have seen oppression, places of worship are also social occasions. So why are they social occasions? That is the only leisure most women know. That is the only legitimate leisure that they are supposed to enjoy. Because if you go to other places, your leisure is no longer legitimate, it's illicit. So these categories of licit and illicit leisure begin to become issues for a lot of women, because if you don't, leisure is that time when you get social support. You mix with people who can help you through difficulties and through challenges. You're also able to they're able to elicit intelligence for social protection. You share your problems. You alleviate burdens, psychological burdens, social burdens, and many more. But because a lot of women don't have access to leisure of the sort that they can use for these therapeutic social consequences, what happens? You end up with dysfunctions of the mind and of the body. And invariably, you end up with a much more challenging situation than was supposed to be possible. And the only thing we provide in many societies, many of our societies, in response is faith, organized faith. And in organized faith institutions, in many organized faith institutions, women then get further exploited, if not sexploited. Sexploited by the same people who are supposed to afford them licit leisure and licit support. And that sexploitation, we're not even allowed to talk about. Professor Elizabeth has talked about the kind of violence that she encountered on the streets. The sexploitation of places of worship or places that are supposed to provide pastoral care for women is not really discussed. And it seems to me we've got to begin to lift the veil of that, because it is adding to the pathology of challenging social situations that we have in a lot of countries. And I would suggest for those who are interested in the human rights of women that we actually begin to look at leisure and access to leisure for evidence of what it says about the lives of women generally and access to sustainable equality on a global scale. The third issue I want to put on the table is the issue of legal capacity. Those who are interested in this will probably remember that one of the first cases, the first major case actually, that the Human Rights Committee under the International Covenant on Civil and Political Rights ever handled under the first optional protocol was the case of Shireen Omiorudi Zifra and Mauritius. Mauritius, of course, being the island off the Indian Ocean to the south of Africa, which concerned the legal capacity of the women of Mauritius to transmit their nationality to their husbands, or for husbands of women, or men who married women of Mauritian nationality to acquire nationality in Mauritius. In 1977, the government of Mauritius changed the law from a situation of equality to one of inequality. So although the men of Mauritius could transmit nationality to their wives who were non-Mauritian, women of Mauritius lost their capacity for their husbands who married them to acquire nationality of Mauritius. And there was no justification for that other than paternalism. The idea being, of course, that men, the traditional notion, or a traditional notion that men are supposed to marry women and women don't ever have to marry men, which really, when you look at, so basically, if you try to unbundle that, in marriage, the man is doing the woman a favor. Essentially, that's the way I read that interpretation. Rightfully, the Human Rights Committee vetoed that and handed down a decision that Mauritius, to its credit, implemented in amending the law so that it returned the situation to one of equality. But at the heart of this is a narrative of inequality of legal capacity. And the inequality of legal capacity means that in most countries, most women are unable to access that basic right that is promised in Article 2.3 of the International Covenant on Civil and Political Rights, the right to remedies. And for various reasons, some of them are adjectival, some of them are evidentiary, but most of them are structural. And the structural reason is down to economic inequality and to social and cultural inequalities, notional inequalities of social and cultural status, that if you're female, somehow your legal status is presumed by the neo-Victorian laws and neo-Victorian mindsets that have framed most of our laws and continue to frame the mindsets of many of our judges in most of our countries. You're presumed to be unequal in terms of your legal entitlements. Now, Article 15 of the CEDAW requires countries to equalize legal capacity between men and women. But in most of our countries, that is not so. So if you're a woman and you've gone to the police station to try to stand surety for somebody, quite often you're going to encounter difficulties. In many countries, many developing countries, they will ask you, what are you doing here? If you go to a bank, they will ask, still today in many places, where is your husband's consent? Why are you taking credit when you're a married woman without your husband's consent? If you are looking to basically access to credit, you're asked about what is the name of your husband. But this is not just the thing. In many of our countries, your average woman will take a goodwill write down because she is trying to get married. She's expected to change her name. And I keep asking my female classmates, every one of whom beat me in class, by the way. The top graduating student in my set was female at every point in time. But today they are all lost. And I had to commit to trying to find all of the females whom I went to high school with, because I was interested to know, where are they now? Most of them were extraordinarily bright. But then pretty much every one of them married and changed her name. And they did not marry as teenagers. You see, if you marry as a 12-year-old, as a 13-year-old, it's one thing. But when you get married as a 30-year-old, having worked as a professional for 12 years, 8 years, 10 years, it's a totally different thing. And then as a 30, 35-year-old, you change your name because you found a man to follow. If that is your decision and you actually calculate with full information that that's what you want to do, I don't have any problem. You're exercising agency. That's what we would argue for. But for most people, this is done under the force of social coercion. It is the thing we are expected to do. And therefore, when you do that, you take a goodwill write down. And anyone who knows basic commerce will tell you that a goodwill write down is the biggest loss you can ever book in any area of enterprise. So most women on the foothills of middle age or midlife will do what? We start from scratch. They will start building new networks of trust, of goodwill, of capability, of everything. It is impossible. That is why, for the most part, many women end up, despite endowments of capability, end up in the networks that sustain life and attainment, being in a much worse situation than men, most of whom cannot tie their shoelaces. That, I think, is a situation we've got to address with socialization, with sensitization. And because this is a university in which there are young people whose lives are hopefully going to outlast those of us who are speaking, I also want to hope that some of them can take away the possibility that these things are not fates. All of what we describe has been socially constructed. Many of them historically, but every one of them can be changed. And for those of you who are in the law faculty as students, but also for those who are teachers here, I think it's important that we commit to the possibility of a different kind of future, normatively, structurally, in terms of consequences, and in terms of constructivism, the kind of society we want to construct, not just in India, not just in Nigeria, but also the kind of international order that underwrites the countries and systems from which we come. I'd like to yield at this point and just continue to thank Professor Tandon and the faculty of University of New Delhi for this opportunity, but also for the privilege of having listened to Vice Chancellor Elizabeth. Thank you very much.
Thank you so much, Professor Chidi. And it was a wonderful discourse. And if I say it is a kind of extension to Professor Elizabeth's lecture, you have provided a very, very different perspective, that is access to leisure, which is often overlooked, and it has not been seen in such a way as you have projected. So in that way, I mean, why still it is a very place-centric when it comes to right to leisure to women. That is a very, very important area to delve into. The other thing you have provided is how the access to credit could be better implemented, how the legal capacity could be more empowered for the women. And in that way, I mean, you rightly pointed out that when we celebrate International Day of Women, we are not celebrating in a sense that everything is done quite well or something like that. But we need to look at how much further it has to go, which you have rightly pointed out. So we need to take a resolve that we have to pinpoint those issues which were not addressed previously. And this kind of sensitization, as you said, that it could be done only through sensitization and realization. And Professor Elizabeth, I sincerely appreciate you because you have boldly shared your encounter and which is needed to be, I mean, spread out all over the country so that people may come and share their views. And people of your stature, if they are sharing, it means a lot to other people. So with this, I'm thankful to you, Professor Chidi. And now I'm inviting the questions, and I invite first Professor Mahavir if he's here.
Just one observation before you take the questions.
Okay, ma'am.
First of all, very many congratulations to the son for the birthday of the mother,
Yes.
Professor Chetty. Yeah, from all of us here. And another thing is, even though each year on the International Women's Day, certain theme is specified by the United Nations. And we must be knowing what is the theme of this year, which is gender equality and sustainable tomorrow. And also there happens to be a campaign theme. Again, we must be knowing that's breaking the biases. But I deviated a little bit from there. And I really wanted to listen the speakers from the area in which they are working. Why? Because that exactly is the learning for us, that whatever you have been working on, what is close to your heart, let you, share with us anything relating to the woman. So I hope that objective, with which I had given this liberty and you quickly that grab that has been fulfilled to a great extent. Your experiences, whatever Professor Elizabeth has given and yours, we could very well relate to our day-to-day lives, family, community, and all that. And we really feel that they're in solidarity that, yes, still a lot more has to be done therein. So with this, these observations, I resist myself from speaking more and would like to give the floor to others who would like to ask questions or contribute. Yes, how we are taking the questions, have they given you written or they will be speaking? How you have, arranged this, Kshitij?
I think I have allowed both the things. You can ask the questions by writing in the chat box, or you can just speak on. So,
Okay.
both the ways.
Right.
Yes, sir. Professor Mahavir, sir.
Okay.
Hello.
Yes, sir.
Ah,
Please go ahead.
yes. Thank you, Dr. I'm having one little bit query from the first speaker. Madam, am I audible to her? Hello.
Yes, you are. Go ahead.
Okay. Thank you, ma'am. Thank you. First of all, we are indebted and we are very much thankful to you for delivering such a wonderful and informative talk to our students as well as our, colleagues. Madam, if I was correct to hear you when you made one sentence that all laws are gender laws, including constitutional law. Am I correct?
You're absolutely right. All laws are gendered.
Okay, including constitutional law.
Every law that has been made has been largely made from a male perspective.
Okay. Yes. Uh, I am asking you, the madam, gender law means that which creates the biasness, है
Mhm.
bias, which creates the biasness for discrimination and inequality.
Right.
But you want to say this thing, na?
Yes.
Okay. Okay, madam. Now I'm little bit confused that I'm a learner of constitutional law. That which provision of the constitution creates the gender constitution, or which becomes bias against the women? Which provision?
Okay. I don't think you got the gist of what I was saying. I wasn't saying any particular provision is against women or discriminates against women. The point that I was making is that these laws, when they are drafted, do not take into consideration the life experiences of other genders. And here I'm particularly talking
Madam,
about
you are very much right, because that you delivered a very good talk, and I'm really
So
really
let her
thankful to you.
speak now. Let her give answer to your question. Yes. He appears to be very excited about his question. Well, that's fine. But yeah, let her give the respond you. Yeah. Then I will also add something.
So it isn't any particular provision, but it is the whole of the law itself that is problematic. So, in the past, when we looked at women and law, we have taken particular laws and said, this law doesn't address, or this section, is discriminatory. But as feminist legal theorists, we are not looking at only sections, because those are not as relevant as the fact that the way in which we look at society, the way in which we look at what conditions in society have to be protected, what are the kind of experiences that result in discrimination against particular groups of people and particular women, then it is trying to see what needs to be done. So if you look at the constitutional law, the rights are largely against the state. Now, women's life experiences are not so much about, the state violating their rights. Not that it doesn't, of course it does, just as much as it violates rights of men. But for women, a lot of the violence and discrimination they experience is within the home. And if you remember that particular case, I can't remember it. It is, a Delhi High Court decision where the judge said that you can't have Articles 14 and 21 inside, a home. That is like setting a bull in a china shop. Because what are we saying? That the right to equality and the right to life are rights which can be exercised against the state and against the public, but not against other individuals, particularly those with whom you are in a relationship. Now, when you look at our entire constitution, the privileging of, fundamental rights over directive principles of state policy in itself is problematic.
Yes, wonderful.
So that is what I'm talking about when I'm saying that all laws are gendered. Because what is it that privileged men, want protected is what is protected and safeguarded and, privileged as rights over others. So if we were to privilege DPSP over, our fundamental rights, the entire economy and polity of India would be drastically different from the kind of India that we are living in today in the 21st century. So that's the point I'm making. And I'm not saying, let's pick out this article or that article is not the point I'm making. We can even do that. But that is, I was making a more general observation of laws in India.
Okay, I will take 1 minute just to strengthen what Professor Elizabeth has said. You see, there is a very good literature of a high standard, which has said that the constitution of the world, okay, UDHR I'm talking about, how that is gender blind, or those said to be gender neutral, but as a matter of fact is based on men's norms. We do say that feminist issues happen to be emotionally charged, and that kind of emotionally charged thing I do find when Professor Mahavir was addressing the question in his voice, even though I could not see him, that comes in your body also, that how come it can be this and that. We do discuss all these things. But if your query is why, because it is an academic discourse, yeah, we should have different views and we should try to argue it or accept the other one. But if your concern is what is the particular provision in the constitution which we can say is not addressing the woman's question, I can give you. Sporting whatever Professor Elizabeth has said, why our Constitution of India is divided into directive principles, state policy, and fundamental rights. Why? And then there is article in the Constitution which says that only fundamental rights are enforceable, directive principles are not enforceable. But the reality is that the life of the woman revolves around part 4, not part 3. Part social and economic, that social political rights. She's not a public player. She's not there in the public life. So the men's who's more active in the public life, who is really exercising the civil and political rights, are protected by our Constitution of India, saying that these are the fundamental rights, and if they are violated, you can go to the court of law. But whatever rights are affected of the women, they are in part 4, and they are made directive principles of state policy. They are just made, okay, state can try, but if there is a violation, you cannot go. So this is here we say that even though Constitution of India is having 14, is having 15, but if we really say it in depth, we cannot say really that it is that woman friendly as it is said. That's one thing. But let me give you the example, because you have said, give me which article of the Constitution. I can give you not one, many. Let us take only one article of the Constitution which guarantees to all its citizens, say, for example, right to education, or say, for example, right to employment. Okay. So it's general. Every person, every citizen is having a right to employment. Let me take that. Okay. There's a husband and wife. Husband is also having a right to employment. Wife is also having right to employment. But what happens? Both have to leave at 9 o'clock in the morning and have to come 5 in the evening. Now, when the husband gets up early in the home, he gets everything. Glass of water, glass of that cup of tea, newspaper, TV, everything, ironed clothes, cooked breakfast, packing lunch, etc. But when the woman has to leave the home for the office at 9 o'clock, she has to do all those kinds of things. Maybe doing herself, or maybe supervising that.
In that context,
So when we are saying, no, let me complete. Let me conclude. So when we are saying right to employment, and when we are saying it is based on male norms, it is based on male norms, even though in the reality, I mean, it's different. How the men and the women actually are involved therein. So these are the things which we really discuss. And of course, as I am again saying, I mean, when gets interested in discussing the things, and the discussions may go on longer, but I think we should move on to take other questions also.
Okay, ma'am.
We cannot say that the discussion is closed or complete answer, because the women questions are like this.
Okay, ma'am. Okay.
Women questions may not have an answer. They may not have pro and con.
Right.
They are having multiple directions.
Right.
Yeah. So we are just growing with these discussions.
Right.
Yeah.
You can.
Yeah.
There is another question. If I take the first from student, then I will allow, to others. So it is a PhD student. He's Kamal Beniwal, and he's asking that what is the role of custom? Or in other way, how can custom help to decrease the women discrimination? So,
I think Professor Chiddi has talked about the custom, worship, and other things. Would you like to address?
Sorry, the question is, what is the role of custom?
Yeah.
Well, there is a general right, I believe in Article 27 of the International Covenant on Civil and Political Rights, as well as in Article 13 of the Convention on the Elimination of All Forms of Discrimination Against Women, to the enjoyment of custom. That's the first thing. The question now is, what constitutes custom? In many of our countries, it is difficult to know what custom is because of the interposition of the colonial environment, of the colonial experience. There is a classic book on the invention of tradition by Hobsbawm and Ranger Eric Hobsbawm and Terence Ranger. And a lot of what we call custom in many of the colonized countries was actually invented. And the colonialists didn't just finish inventing them, they subjected them to standards of, to externalities in terms of their normative validity. And so you had these notions of compatibility tests, that a custom had to be compatible with essentially notions of colonial morality, of Victorian morality. And by the time that we got independence, starting with the partition, of course, of India in 47 and moving on from there, you had notions of judicial notice that had evolved based on these outcomes of colonial invention. Now, customs, by the way, in most societies that have them, are practices that only evidence fundamental values of coexistence. Many of those values would have risen in the society, so you adapt them over time, but the values are unchanging. And I'll give you one example. Where I come from, in most parts of Africa, actually, when a first-time mother whose mother is alive would welcome her mother, the mother would actually go to help her through with understanding the challenges of maternity, of having a new baby in the family. And these are mechanisms by which you transmit skills across generations and create mechanisms also of support, because several young mothers could have postpartum depression. You don't know how to handle it. You don't have anyone to trust. This may be the only person to trust. But these days, because we now have nuclear family units in which many people don't have the relationships that underpin family relations, we no longer have these kinds of support systems. And when young women go through postpartum depression or postpartum challenges, there is no circle of trust that they have to live with. Now, this is just one example of a practice in custom, because a lot of people think everything about custom is evil. There are obviously things about custom that require transformation. There are structural reforms that could take place in custom, because the underlying challenge with custom was that it was built on intrusive, familial society. And much of it may not be able to travel across in the kind of society, anonymous society, that is based on civics, not on family or filial relations. So to scale, the social framework of custom actually does vary. Historically, custom has come under serious challenges with reference to the origins and this contact with colonialism. But it seems to me the important thing is to extract the values from customs that are adaptable with the times. And I should just say this, that we need to be careful about assertions of universality that are not grounded in authenticity. Every society has got values of dignity, I think, that are important to it. It is patriarchy and masculinization that actually changed and altered the trajectory of custom. That's just the final point I wish to make. Thank you.
Thank you. So Dr. Anu was there if she wishes to ask anything. Otherwise, I will take the question from chat box. So, ma'am.
Yes, Dr. Shitek, thank you so much for giving me this opportunity. First of all, it is just an observation that it is a wonderful talk. I thank you, all of you that organized this kind of talk, and both the speakers are so wonderfully, reflected on the issues on gender. As I am also having, heading this committee in my center, Gender Sensitization Committee, and through the experiences of various speakers, I agree with Madam Elizabeth that yes, this is the going off the social norms and gender norm in the society, the two areas in bifurcating with the experiences, practices. And I agree with Professor Tandon also that yes, this is the way how women is being treated in the society. Though we are entering into 21st century, and throughout the globalized world, this talk is in 21st century been organized on 8th March, and everywhere it has been said that women-led development or women empowerment we talk, but still the basic necessities in the society we are fighting for. Like if we go in the interiors, the basic toilet facilities, our women has been facing this scarcity, and through the on the way the crimes are being committed. As Nirbhaya is the example, other every day we are NCRB data everywhere we see such kind of reports. So I think only the sensitization and the awareness among us are, as the educated one, और मुट्ठी भर लोग जिसको कहते हैं, उनको ये फैसिलिटीज मिली हैं, और जो एजुकेटेड है, एम्पावर्ड है, मुझे लगता है बहुत ज्यादा अभी माइल्स टू गो ऑन, मतलब इस एरिया को लेकर के.
Yes. Yeah.
Thank you so much. Thank you so much.
I think we can take two more questions. Why? Because it will be too late for Professor Chidi. Yes. Can we take two more questions, Professor Chidi, or only one question more?
Please, no, that's fine.
Okay.
Okay. So I will be taking the shorter ones because the others are very time-taking. So one question is whether the laws today, which are prevalent, they are dealing with the psychological issue related to women. That is one of the questions. And
sorry, can you take that question again? I didn't.
I mean the psychological aspects of women, whether they are being properly addressed by the laws which are prevalent right now.
The psychological aspects of women, whether they're being
women issues. Yeah.
I mean, look, we're all. I don't know. There's an undercurrent to that question that kind of suggests women are kind of, a different species. At the end of the day, we're all in the family of Homo sapiens, and every one of us has a psychological dimension. And I relate that to the other question here by Ezekiel. Can it be said that, in fact, implementation of law rather than law itself is gendered? Both are gendered. The law is gendered historically. And I think, I can't improve upon the way that Professor Lisbeth has made it. So look, in 1872, the United States Supreme Court decided that women could not be enrolled to practice law because their place was the kitchen and the bedroom. You should read that decision in Bradley and Illinois. And women only won the right to join the legal profession in the United Kingdom, by the way, in England in 1919, basically 100 years ago. And that is why that traditionally the legal profession everywhere has been misogynistic. There's been a bastion to misogyny because women were historically excluded from the law and from the legal processes from the processes of the law and from lawmaking. That is just fact. I come from a country in which women won the right to vote and be voted for in 1976. Universal suffrage for women in my country was only achieved in 1976. Women in Saudi Arabia only won the right to drive a car, when? 2 years ago? And universal suffrage in many countries in the world was achieved in the lifetime of many of us here. So the idea that law is gendered is not such a highfalutin idea. Nothing for us without us, except women, of course, for whom we have all made laws throughout the ages without the participation of women. That is just the basic fact. Now, the fact, of course, that women were not part of lawmaking then became a factor in law enforcement, and that has continued till date. So it's not either or, it is actually both, that law is gendered and its enforcement is gendered. That is why if you go to a police station to be a surety for bail, a man behind the counter will tell you to do what? That you're a woman and you're not supposed to stand surety because you're a woman. It's as simple as that. So I think that hopefully that takes care of the two dimensions to the question, but I'm sure that Professor Elizabeth may also have something to say about that.
Yes, what I've done is, I have messaged itself to say that it is not just the law that is, it's not just the implementation. Implementation is more in terms of interpreting the law and enforcing it, where, it's obvious to all of us if, the judges are misogynistic or they don't take into consideration the experience of women, then yes, it both there as well as, of course, the police are responsible for enforcing the law, not just enforcing, in fact, even the investigation of the law. You see them completely neglecting crimes against women, shoddy investigation like we do in the dowry-related deaths of women, which results in it. But I'm saying it's not just in the enforcement and interpretation of the law, but the very way in which the laws have been drafted, the way in which we conceptualize these crimes against women or, experiences of women, which are completely ignored. And as a result of ignoring women's experiences, they're conceptualized purely from a man's experience. And that is the most obvious example is what I told you, Section 375. The penile penetration of the vagina had nothing to do with women's experience of rape, but rather how men saw rape and, the problem with rape. And therefore, it was conceptualized to all the other things that I've said, like till the 1983 amendments to the CRPC and the Indian Evidence Act, we went into the prior history of a woman. Look at the way in which we explain what is consent. All of these is problematic with the way in which we are conceptualizing these crimes and not merely in the interpretation and enforcement of these laws. So it is both, as Professor Chedi said, it's both. It's if you see it in the very conceptualization and in the laws themselves, as well as, of course, in the interpretation. So you can have laws which have been like the 2005 Domestic Violence Act, which has been drafted in such a gender sensitive manner. And then you have Supreme Court judges who completely ignore the reason for the provisions and say, you can't, women cannot claim right of residence in property that belongs to the in-laws, etc. So you have, a good law which can be interpreted, badly again. And for the simple reason that you live in patriarchal societies and where you want to protect patriarchal interests. And as a consequence, it doesn't matter what kind of laws we enact, so long as there is no gender sensitization, and it can't be 1 hour gender sensitization where nothing, is achieved. That is simply, a token kind of, sensitization program that we have in many institutions.
Yeah, just for a while, I think one of the questions in the initial was whether psychological factors relating to women are taken care of by the law. Just to that, I think whosoever asked this question, he can locate the answers in the areas, whatever has been talked about here in, say, for example, custody issue of the child, or Geeta Hariharan thing is also talked about in that, adoption also in that, though psychological, these are very, very close to a woman. And when we talk about the family law, wherever she's not even, till date, she's not even recognized the natural guardian. So how could it affect her? So many other kind of things are there. A 2005 amendment came only now. She was not given the property rights law. So of course it has a psychological effect. I think you can relate most of the laws when if you want to analyze whether the psychological factors relating to the woman are taken care of by the law or not. And even the law of rape, sexual harassment, it was only as been explained here in 2013 that all these things, whatever example she has narrated of that. So all these have psychological impact. The crimes against a woman is a best example to say psychological effect against a woman. So the laws are again in the process of being improved. and so on and so. This is how the same thing we can see from this perspective also.
Okay,
You can
ma'am.
take
So
the last question, I think.
yeah, there are a few questions which are very factual in nature. So, I mean, how can you increase the reporting regarding that, and the others based on opinions? So, if you can give your take on that, the reporting thing, so that would be fine, I think.
Yeah, sure. How do you increase reporting? You'll have to look at the reasons for why people don't report. So unless we conduct research into the reasons why women are not reporting cases of sexual assault or domestic violence, you cannot really find a solution. And I think, that's the reason why we need to get into interdisciplinary research. When you're just looking at the law and critiquing the law and, do shoddy empirical research work, it doesn't result in finding solutions. So if you, based on the little that I do know in terms of, work that I have done or people that I've spoken to, why do women not report? When it comes to sexual assault cases, you have a society that doesn't facilitate it. Your family will be the first point. So, in fact, if you look at, as law students, all you need to look at the cases, right? You have courts which will not accept reporting which has happened later. There are so many cases that have come, a week later, a month later. In fact, we had very recent cases even during this pandemic in UP. We had so many cases of Dalit women who were sexually assaulted and resulted in their death. And the reporting happened later. Now, why did that happen, right? When you look at it, one is the society itself, your family, which prevents you from reporting. You may not even tell your family that you've been sexually assaulted because the family blames the person who has survived such an assault. So you don't report because the first question that we asked is, what were you doing there? Why did you go there? Why he chose you to sexually assault you? Even sexual harassment, you can't talk about it to your families. So that will be your first obstacle. Which means you have to go around, educating your parents, your other members of your family. Then comes the rest of society. What will the neighbors think? What will our relatives think if you go and report it? Then another dimension, if you leave then, is reporting in the police station. Are police stations so women friendly that, you're sexually harassed even, that you'll want to go there and tell them this has happened? I want to report a crime. Even when, sexual harassment cases women have gone to report, the first question some constables have asked is, what were you doing? I mean, was it in the midnight that you were sexually harassed? You're sexually harassed any time during the day. And when there are several young women, they're even middle-aged and older women, we are walking to buy medicine. We are walking to a store to pick up things, or we have bought something and we're walking back home. We are walking from our workplace to the bus stop. These are the times when sexual harassment happens. And what does a constable mean by asking you the question, what were you doing? Right? And so when these are the kind of questions that are asked, this is the kind of ways in which people look at you, then you decide not to go and report. What is going to come out of it? Right? And if it is sexual assault, sexual harassment by a stranger, you don't even know who this person is. And then the police will tell you, we cannot help you if you can't tell us who it is. If it is somebody who is in your family, first of all, there is the obstacle in the family. Look at all the, sexual offenses against children cases. It is your own father, it is your teacher, your uncle, your cousin, your grandfather. How do you report crimes that are committed by your foreign family members? And if you go to report it, the question oftentimes that is asked is, how can you say something like this about your own father? And then oftentimes it's like your mother is instigating you to do it, right? So when these kind of, experiences are there and are shared, then obviously women hesitate to report. So what do you do is to change the way our society functions. Unless you can make it easy, convenient, acceptable, and one where when a woman reports, people will believe, then reporting of these kind of crimes against women is not obviously going to go up. So you need transformation of society. Unless this male domination of society ends, where you're seeing a man and looking at everything only in terms of his interest. Look at what happens in college campuses. At NLS, where I used to be, oftentimes a young female student was dissuaded from reporting because look at his future, what will happen to his future? I remember in one case, they even talked about how his scholarship will be discontinued. His mother is very ill. I mean, those are things he needed to think about. Why must I have to think about his welfare, his family? Why didn't he think about these things? That if she reports this, when I commit this crime, I'm going to lose my scholarship, my mother is going to die. Why must the woman who is subjected to sexual violence be concerned with these things? And therefore, female students on campus don't report these crimes. These were all informally reported to me. So I know the extent to which these things happen on campus. So how do we do this? Till we start valuing women and their experiences and look at these crimes as, really problematic to society, you're not going to have the environment in which women will be encouraged to report these crimes.
Yes. Very well. I think we now proceed to wind up.
Yeah,
I'm very cautious that it's 1 a.m. at Boston and that is not making,
So I'm inviting my colleague, Dr. Naren Kumar Bisnoi, for a vote of thanks. So over to you, Dr. Bisnoi.
Respected distinguished speakers, Professor V.S. Elizabeth, Vice Chancellor, National Law University, Tamil Nadu, Professor G.D. Anslem, Professor Fletcher Law School, Professor Usa Tandon, Head and Dean, Faculty of Law, Professor Mahavir Singh, Professor in Charge, Law Center 2, Professor Kiran, Dr. Anu, Dr. Avikta Verma, and various other faculty members and dear students. Good morning to all of you. On behalf of faculty of law, I express my heartfelt thanks, first of all, to two distinguished speakers who spare their valuable time and join us in this international webinar. We are grateful to Professor V.S. Elizabeth, who explains various crimes against women and their critics, how it is basically misused. But just because the laws are misused, it does not mean that law should not be made. So while reading those crimes against women, we should always take the feminist perspective in our mind. Thank you, ma'am, for your path-breaking statement that will enlighten us. We are also grateful to Professor Chidi for discussing with us the three-dimensional model of women empowerment or gender equality. They're talking about basically equality, quality, and accountability. And thank you, sir, for your valuable thought that will helping us, all of us. I also thanks our professor, our well-wisher, Professor Usa Tandon, ma'am, for her constant support, vision, and commitment for the betterment of this faculty by encouraging us to organize these international and national webinars. I also want to thank Dr. Siti Singh, director of this webinar, for conducting this program smoothly, and especially for this interactive question answer session. I also want to thank Mr. J.P. Meena for his support. Last but most important, I want to thank all the faculty members and the dear students who joined us by Zoom link or watching this webinar on YouTube for their active participations for the success of this international webinar. Thank you.
So, there happens to be a formal vote of thanks, but thank you very much to both of you. And I think I will say good night, Professor Chidi. Thank you. Thank you. So I think we can disconnect.
Yes.